not served any letter and not paid anything in lieu of notice was not pleaded. It is the law that evidence adduced on facts not pleaded is inadmissible and must be rejected by the court. See Adake versus Akun, 2003. Even if this court decides to consider the evidence of the claimant that he was not served any letter and not paid anything in lieu of notice, there is still a problem. First, he never told the court that the letter he was expecting to be served to terminate his employment other than the retirement letter. Second, before the claimant can be heard to say he was not paid anything in lieu of notice, he must have first explained to the court that he was entitled to notice, the duration of the notice, what entitled him to notice, and in lieu thereof, what he is entitled to be paid. It is after these facts have been placed before the court that the court can properly believe that the failure to pay him anything in lieu of notice was a breach of the condition of service. In his evidence, the claimant merely said he was not paid anything in lieu of notice without any prior evidence that he was entitled to notice and duration of the notice. When an employee complains of wrongful termination of his employment, the employee has the duty to plead and prove the terms of his contract of employment, how the employment can be terminated under the condition of service, and the manner the terms of the contract were breached by the employer when his employment was terminated. See WAEC versus Oshonebo 2007, Petroleum Training Institute versus Matthew 2012. Let me add that Relief 1 sought by the claimant is a declaratory claim. Before the court can make a declaration that the termination of the claimant's employment was wrongful, the claimant must plead and prove what made the termination wrongful. In this case, the claimant failed to plead and prove the procedure in the junior team member condition of service by which he can be retired from the employment. He also failed to plead and prove how his retirement contravened the terms of the junior team member condition of service. Although the junior team member condition of service is in evidence as exhibit, it is, however, not the duty of the court to examine it to find how it supports the claimant's case when the claimant did not plead the material facts. It is the duty of the claimant to plead the essential facts before the court can examine the document to see or find how it supports the averments of the claimant. I have seen the letter of retirement where the defendant said the claimant was retired because of the challenges and economic problems caused by the COVID-19 pandemic to the defendant's business. In his amended statement of defense, as well as in the evidence of DW, the defendant stated that as a result of the challenges caused by the COVID-19 pandemic, it carried out restructuring exercise in 2020, and in that exercise, it had to retire 450 staff members, including the claimant. The retired staff were paid all their entitlements. The claimant accepted his retirement and collected all his entitlements, including 6 months basic salary in lieu of notice. The claimant did not dispute these facts in his reply to the statement of defense, and he did not adduce evidence to challenge the evidence of DW on the facts. Upon a thorough examination of the pleadings and evidence of the claimant with respect to his claims for wrongful termination of his employment, I find that he failed to establish the claims. Now to reliefs 2, 3, 4, 7, and 8. In paragraph 61 of the defendant's amended statement of defense, the defendant pleaded that the claimant's claim for a compensation is statute barred because the accident happened over 20 years ago. The defendant averred that the claim ought to be dismissed. In the final written address of the defendant, it was submitted in issue 1 thereof that the claimant's claims, which is founded on negligence or breach of duty of care by the defendant, is statute barred by the effect of section 7 subsection 4 and section 8 subsections 1 and 2 of the Limitation Act. It was further submitted that by Exhibit 22 or TH16, the claimant had the accident over 20 years ago, but when he filed this suit in May 2022, the suit was already statute barred. Learned counsel for the defendant concluded that this court lacks jurisdiction to entertain this suit and urged the court to dismiss the suit. In paragraphs 12 and 13 of his reply to statement of defense, the claimant pleaded that he was retired from the service of the defendant in December 2020, and he instituted this suit on 17th May 2022, which is a period less than 6 years from when he was retired. He also averred that during his employment, he had no cause to institute action against the defendant because the defendant was taking care of his ailment until he retired from the employment. Strangely, there was no response in the claimant's final written address to the submission of the counsel for the defendant. From the arguments in issue 1 of the defendant's final address, the issues raised pertain to the competence of the claimant's reliefs 2, 3, 4, 7, and 8, with the consequential effect on the jurisdiction of this court to entertain or determine these claims. The law is settled that any objection which touches on the jurisdiction of the court must be considered and determined first before the court can take any other step in the proceedings. CTOMC Nigeria Limited versus UTC PLC 2003. Let me therefore determine whether the claims in reliefs 2, 3, 4, 7, and 8 are statute barred or not. The implication of Section 8(1) and 2 of the Limitation Act is that any action which a claim is made for damages, any action in which a claim is made for damages for negligence or breach of duty or damages in respect of personal injuries to any person, such action shall be instituted within a period of 3 years from the date on which the cause of action accrued. Where any action in respect of the mentioned subject matters is not filed within the period of 3 years as specified, the action will be statute barred and cannot be entertained by the courts. See Elebanjo versus Daodu, 2006. In reliefs 3 and 4, the claimant sought the court to declare that the accident in which the chemicals splashed into his right eye happened because the defendant failed to make provision for the protection of his eyes during the course of performing his duty. In relief 7, he sought an order directing the defendant to finance the transplant of his right eye damaged by the chemical. And in relief 8, the claimant sought general damages for permanent incapacity or loss of his right eye while on duty. These claims of the claimant in reliefs 2, 3, 4, and 7 are claims in respect of personal injury to the claimant's right eye, which occurred during the course of his employment, and which injury is said to have resulted from the negligence or breach of the defendant's duty of care. In paragraph 7 and 8 of the statement of facts, the claimant averred that in the course of carrying out his duties as laundry attendant in the laundry department of the defendant, a stain-removing chemical splashed into his right eye and injured it. The injury caused him permanent deformity in the right eye, and on 5th April 2000, he was referred to the National Hospital, Abuja, by the defendant's clinic for the hospital to do necessary medical treatment and or hospitalization. Then in paragraphs 12, he pleaded that in paragraph 12, he pleaded that on 27th August 2001, the National Hospital issued a medical report to the defendant, wherein it was stated that he has recovered and can resume normal duties. From paragraphs 18 to 29, the claimant pleaded that he was having recurrent pains in the right eye as a result of the chemical that entered his right eye, and he has been taking treatment since December 2008 up till November 2020. When he was retired, up till November 2020, when he was retired from the service of the defendant, the claimant instituted this suit on 17th May 2022. From the facts pleaded by the claimant, the claims of the claimant in reliefs 2, 3, 4, 7, and 8 are based on the incidence of chemicals splashing into his right eye while at work. The claimant did not mention the exact date it happened, but the earliest time he mentioned a referral to a hospital was on 19 September 2000, as pleaded in paragraph 9, when he was referred to the National Hospital. In cross-examination, he said, after the accident, the in-house clinic of the defendant treated him for about 6 months before he was referred to the National Hospital. This implies that the claimant had the accident at about the month of February 2000. Now, the claimant alleged in paragraph 41 of the statement of facts that the chemical splashed into his right eye because the defendant did not give him protective tools that would have prevented or protected his eyes from the splashed chemicals. Since the claimant alleged that the injury happened to him because of the negligence or breach of duty of care by the defendant, the claimant's cause of action arose from the date the injury happened to him. Thus, the cause of action of the claimant in respect of reliefs 4, 5, and 8 arose at the time the accident happened in February 2000. By the provisions of Section 8, 1, and 2 of the Limitation Act, the claimant ought to have filed this case within 3 years from the date his cause of action arose. When the claimant filed this suit on 17th May 2022, he filed the suit about 22 years from the time his cause of action arose. It is clear that the claimant filed the suit outside the period limited in the Limitation Act for him to do so. The claimant pleaded in his reply that during his employment, he had no cause to institute action against the defendant because the defendant was taking care of his ailment until he retired from the employment. This excuse does not avail the claimant. The time to seek redress in court against the defendant with respect to the injury he said he sustained while on duty started counting against the claimant from the day he sustained the injury. He cannot keep his rights of action on hold because he was still in the employment and expect the limitation period to freeze. While he can decide not to sue until he leaves the employment, the Limitation Act is not so patient or benevolent. By the time set by the Limitation Act continues to run from the moment the cause of action arose. In Cross River University of Technology, Cross Rivers University of Technology versus Oberten 2012, it was held thus. A cause of action accrues on the particular date which gave rise to the incidents in question. For the purposeful intendment of statutes with stipulation of durational limitation, the clock begins to wind down and time begins to run from the moment which culminates into the date on which the cause of action accrues, unquote. See also Daoud versus Ajose 2011, where it was stated that time begins to run for the filing of an action when the cause of action arose. This means that once there exists two people with interest at variance to each other over a subject matter, then the aggrieved party must go to court timelessly. In view of the foregoing, I find that the claimant filed his claims in reliefs 2, 3, 4, 7, and 8 against the defendant outside the limitation period prescribed in Section 8, 1, and 2 of the Limitation Act. Consequently, reliefs 2, 3, 4, 7, and 8 are statute barred, and this court lacks jurisdiction to entertain same. In the circumstance, the appropriate order to make is that of dismissal of these claims. It is clear that all the relief sought by the claimant deserve to be dismissed. This suit is hereby dismissed. Parties shall bear their costs. Judgment is entered accordingly.
Hello, we thank this honorable court for this well-considered judgments.
Thank you.
Pray the Almighty God to continue to give your lordship wisdom and good health to carry out.
Thank you very much.
Yes, madam. Grateful, sir.
Thank you.
Yes, sir.
Thank you.
Yes.
So you get your drawn up your judgments later today.
As you copy this. We're grateful, sir.
Yes.
Grateful,
Thank you.
sir. Grateful, sir. Long live the court, sir. Thank you, sir.
Thank you.
Yes, ma'am.
Yes, my lord. Number 2.
Yes.
Case number NSCN/ABJ/130/2020 to Mr. Mobolaji Ajani and Gado Agency Limited, Mr. Godwin Odimeje. Lord, parties absent.
Okay. Appearances.
May it please your lordship. My name
Yes.
my name is Monica Umeche. I hold the brief of Adebayo Adetomiwa for the matter.
The brief of Adebayo
Adetomiwa. Yes, sir. My humble appearances for the claimant. This.
Yes. Any representation for the defendant?
No, my lord.
Yeah, that. Where's Isaac Odebumi is online?
Who?
Isaac Odebumi. I see
Mr.
him.
Isaac Odebumi, are you there? His microphone seems to be muted. Can you unmute your mic and announce your appearance, please? Are you sure that Isaac you are saying is Odebumi?
Maybe.
It's all right. This one is 1:30, right?
Yes, my lord.
Okay, so I'll proceed to deliver the judgment, and I'm reading from my computer.
I'll copy.
By a complaint filed by the claimant on 23rd June 2020, he sought the following claims against the defendants. The claims are listed out from 1 to 7. The defendants filed an amended statement of defense together with a counterclaim against the claimant on 8 April 2022. The claims sought by the defendants in the counterclaim are as follows. The claims are listed as 1 to 7. I have summarized the case of the claimant and the case of the defendants as well. And I have also touched on the final addresses. I'll go straight to the decision. First, I will deal with the decision on the claimant's claims. The claims of the claimant include claims in defamation, see reliefs 2, 4, and 5. From the evidence of the claimant, he was no longer an employee of the defendant when the disclaimer which gave rise to his claims in defamation was published. Let me emphasize the position of the law with respect to joinder of claims in defamation to an action between employee and employer in this court. The subject matters which this court can entertain are spelled out in Section 254C of the Constitution of the Federal Republic of Nigeria, 1999. These subject matters within the jurisdiction of this court do not include actions in defamation, which is an action in the realm of torts. See Akpan versus University of Calabar 2016. See also EcoBank Nigeria Limited versus Idris 2021, where the Court of Appeal held the view that cases or matters which border on the tort of defamation is not one of the subject matters within the jurisdiction of the court in Section 254C 1, 2, and 3 of the 1999 Constitution. The Court of Appeal clarified that even if the Tortures Act happened in the course of the employment, it cannot be used to expand the jurisdiction of this court beyond its jurisdictional scope in Section 254C 1, 2, and 3. It is therefore obvious that this court lacks jurisdiction to entertain the claims in reliefs 2, 4, and 5. These claims are struck out. The claims of the claimant, which are properly brought before this court for determination, are reliefs 1 and 3. In relief 1, he sought a declaration that he is entitled to payment of his outstanding remunerations and allowances as at the time of his voluntary resignation from the first defendant's employment. And in Relief 3, he sought an order directing the defendants to pay him the sum of 2,831,666 naira, being his total outstanding remuneration, commission, and allowances. Relief 6 and 7 are merely ancillary. To determine these claims, I will consider the issue whether the claimant has proved the claims and entitled to the grant of his claims. The claimant was employed by the first defendant on 1st December 2009, and he resigned from the employment by the letter dated 16 June 2019. He stated in his evidence that the defendants are indebted to him to the tune of 2,831,666. He said this sum is the total outstanding remunerations and allowances due to him, which has not been paid to him till date. He also said he is entitled to the sum and proceeded to explain how the sum accrued as follows. 230,000 naira being producers' fees for 23 editions of Money and the Economy radio production undertaken for the CBN and executed between 14 December 2018 and 14 June 2019. Each edition was produced at 10,000 naira. 2. 90,000 naira being producers' fee for 9 editions of NAFDAC and Your Health radio production executed between 30th November 2017 and 25th January 2018 at 10,000 naira per edition. 3. 100,000 naira being producers' fees for 10 editions of NAFDAC and Your Health radio production executed between 8 April 2019 and 10 June 2019 at 10,000 naira per production per edition. Then 4. 1,755,000 naira being payments for work undertaken and executed in respect of 13 units of Nigerian Urban Reproductive Health Initiative NURHI jingles between May and June 2019. This sum covers scripting 45,000 naira times 13 units equals 585,000 naira. Editing 40,000 naira times 13 units equals 520,000 naira. Production director 25,000 naira times 13 units equals 325,000 naira. Producer 25,000 naira times 13 units equals 325,000 naira. And then 500,000 naira being unpaid annual leave allowance at 50% of monthly basic salary for 10 years. 6. 56,666 naira being prorated salary for the work period from 1st to 17th June 2019. And then 7. 100,000 naira being 1 month salary in lieu of notice. In defense of these claims, the defendants aver that they did owe the claimant and that they did not owe the claimant any remuneration, salary, or allowances, nor are they indebted to the claimant to the sum of 2,831,666 or any amount at all. The defendants further explained that the claimant's remuneration, allowances, or entitlements in the employment were stipulated in his appointment letters, and that all the work performed by the claimant during the employment were carried out by virtue of the contract of employment between him and the first defendant, and the claimant was remunerated for his work at the end of each month. The defendants averred also that the products, all scripts written, programs produced, or drama acted in the television or radio by the claimant during his employment with the defendants are productions or properties of the defendants, and these scripts written, programs produced, or drama acted were done by team efforts of the staff, and the equipment of the defendants were used. The claimant said the sums of money he is entitled to in subparagraphs A to D of paragraph 31 of the statement of facts are producers' fees for the various productions he referred to in the subparagraphs. Although I have seen the term of the employment in the claimant's promotion letter dated 25th April 2017, that he is entitled to production allowance at 10,000 naira per edition have not been shown the productions or programs referred to in subparagraphs A to D of paragraph 31 of the statement of facts for which he sought to be paid producer's fee or allowance. It is not sufficient to simply seek to be paid for editions of some productions he did for the defendants and stop there. The claimant must go further to show that the productions are not fictional but real. I cannot be convinced that the claimant is entitled to producer's fees until he proves that he did produce what he wants to be paid for. No such evidence has been shown to me. Claims for debt or money owed are claims in special damages. The claimants must prove. There's also the amount of 500,000 naira, which the claimant mentioned in paragraph 31E of the statement of facts as unpaid annual leave allowance at 50% of monthly basic salary for 10 years. That is to say, the claimant calculated 50,000 naira as 50% of his monthly salaries and multiplied it by 10 years. I find a number of faults with this claim. The claimant was employed in December 2009 and he resigned in June 2019. This period is not up to 10 years. Again, the claimant failed to place the basis upon which he arrived at the sum of 500,000 naira before the court. He did not plead or state in his evidence the amount of his monthly salaries in each year of his employment. This failure creates a doubt as to how the claimant arrived at the sum he claims as outstanding leave allowance. I will not waste further time on this aspect of his claim than to dismiss it as unproved. By Exhibit C7, dated 16 June 2019, the claimant resigned from the first defendant's employment with effect from 30 June 2019. The defendants responded in Exhibit C2, dated 17 June 2019, to inform the claimant that the resignation should be with immediate effect, as the defendants cannot allow him to remain in the employment during the notice period. By the content of Exhibit C2, the defendants accepted the claimant's resignation, but commuted the notice period or waived the notice period. The implication is that the claimant, with the consent of the defendants, effectively resigned on 17 June 2019. The sum claimed by the claimant in Relief 3 include the sum of 56,666 naira, which he averred in paragraph 31F of the statement of fact is the prorated salary for the work period from 1st to 17 June 2019. Since the claimant was an employee of the first defendant up to 17th June 2019, he is entitled to his salary for the days he worked for the first defendant in June 2019 before his resignation became effective. The claimant is entitled to the salary for the period from 1st June to 17 June 2019. The claimant, however, failed to mention the amount of his monthly salary as to enable the court determine whether the prorated amount is correct or not. This is more so that the defendants pleaded in paragraph 38 of the amended statement of defense that the claimant's monthly salary between July 2018 and May 2019 was the sum of 114,915 naira 63 kobo. I've also seen paragraph 31G of the statement of facts where the claimant mentioned 100,000 naira as 1 month's salary in lieu of notice. I'm therefore not convinced that the sum of 56,666 naira represent half a month's salary, which he ought to be paid for the period of 1st June 2019 to 17 June 2019. Be that as it may, the claimant is entitled to be paid what accrued to him for that period. The sum claimed by the claimant in Relief 3 include the sum of 100,000 naira, which he described in paragraph 31G of the statement of facts as 1 month's salary in lieu of notice, except in paragraph 31G where he mentioned 1 month's salary in lieu of notice. The claimant did not plead anywhere that he was entitled to notice of termination from the defendants or payment of salary in lieu. His oral evidence did not also extend to such facts. Again, the claimant simply averred in paragraph 31 that the sum he claims include 100,000 naira salary in lieu of notice, without previously pleading or stating how much was his monthly salary at the time of his exit from the employment. Most importantly, the claimant did not even aver that the defendant terminated his employment. Evidence abundantly shows that it was the claimant who resigned from the employment. How then did he expect the defendants to pay him salary in lieu of notice? Perhaps his belief is that the defendants terminated his employment when the defendants wrote to him after he submitted his resignation letter to inform him that his resignation should be immediate rather than lasting till the notice period. That is why he thinks he should be paid 1 month's salary in lieu of notice by the defendants. I disagree with the claimant. He brought the employment to an end by his notice of resignation. Accordingly, the defendants do not have any obligation to pay him salary in lieu of notice. The end result of the case of the claimant is that reliefs 2, 4, and 5 are struck out, while, except to order the defendants to pay the claimant his salary for the period 1st June 2019 to 17 June 2019, his claims in reliefs 1, 3, 5, 6, and 7 fail, and they are dismissed. Now I'll go to the decision on the defendant's counterclaim. Having carefully examined the claims sought by the defendants in their counterclaim, and having gone through the facts in support of the counterclaim, it is observed that 2 main claims have been made against the claimant. The first is for the return of the defendant's properties in his possession. See reliefs 1 and 4 of the counterclaim. The second is for payment of outstanding loans or money borrowed from the defendants during his employment. See reliefs 2 and 3 of the counterclaim. It is the case of the defendants that during the claimant's employment with the first defendant, the claimant was given a staff identity card, and some properties of the first defendant were in his custody, including HP laptop. When the claimant resigned from the employment, it was on 21st June 2019 that he handed over some properties of the first defendant in his possession, but he did not hand over his staff identity card and the HP laptop assigned to him as his official computer to perform his work. Although the claimant handed over a HP laptop to John Chukwuma, the laptop he handed over is different from the model given to him. The defendants have averred that the cost of the laptop is 250,000 naira. It is for this reason the defendants sought in reliefs 1 and 4 of the counterclaim that it be declared that the claimant's refusal to hand over the staff ID card and HP laptop amounts to a breach of contract, and to order the claimant to return the ID card and HP laptop or pay the sum of 250,000 naira, being the price of the laptop, to the first defendant. In his evidence, the claimant said upon his exit from the employment, he prepared his handover notes and submitted it to the defendants on 21st June 2019. He also handed over all official properties belonging to the defendants, which include transactional documents, files, electronic and hard copies, official computer assigned to him, cameras, recorders, laptop, computer, hard drives, staff ID card, and other items in his care, to the first defendant. He said there was an inventory of all the items he submitted, and it was acknowledged by Mr. John Chukwuma. The items were inspected and confirmed by Mr. John Chukwuma, who also acknowledged the handover notes on behalf of the defendants. I have seen the claimant's handover notes dated 21st June 2019, which was acknowledged by John Chukwuma on 29 June 2019. The document is Exhibit C8. One of the items the claimant handed over to John Chukwuma is a laptop. The defendants confirmed that the claimant handed over an HP laptop to John Chukwuma when he resigned. He said John Chukwuma is DW2. He said among the items handed over to him by the claimant is a HP laptop. It is therefore not in dispute that the laptop given to the claimant was HP, and the claimant handed over a HP laptop to the defendants. The area of dispute is as to the defendant's allegation that the HP laptop handed over by the claimant is different from the one given to the claimant. The burden to prove this assertion of the defendant lies on them. When the defendants allege that the laptop handed over by the claimant is different from the one he was given, one will expect that they will bring evidence to show the laptop given to the claimant and then produce the laptop handed over by the claimant in order to illustrate and establish to the court that what was given to the claimant is not what he handed over. The laptop handed over by the claimant was not produced for the court's inspection, and other than the mere mention that the laptop given to the claimant was HP, there was no other description of the laptop. The defendants failed to discharge the burden placed on them with respect to their allegation. The result is that there is no evidence to prove that the HP laptop handed over by the claimant is not the same as the one he was given during the employment. As for the staff identity card, the parties are adamant on the fact that the claimant was issued one when he was employed. While the claimant said it was one of the items he returned to the defendants claimed that the claimant did not return it. This position of the defendant was the basis of the disclaimer published against the claimant in the Leadership newspaper of 10 September 2019. I have earlier struck out the claims of the claimant found on that disclaimer, thereby leaving the door open for the claimant to litigate his defamatory claim against the defendants in the appropriate court. In my view, it will be prejudicial to the just determination of any action the claimant may decide to pursue on his allegation of the defamation if I proceed to determine in this suit whether the claimant submitted his ID card or not. For this reason, I will refrain from making any pronouncement on the controversy about the claimant's staff ID card. Consequently, I find that the defendant failed to prove reliefs 1 and 4 of their counterclaim. In relief 2 of the counterclaim, the defendants sought a declaration that the claimant is indebted to the defendants from loans or money borrowed by the claimant during his employment. In relief 3, the first defendant sought to recover the sum of 1,540,000 from the claimant, while the second defendant sought to recover the sum of 882,000 naira, 792 naira from the claimant as the claimant's indebtedness to the first and second defendants respectively. In paragraphs 39, 40, 41, and 42 of the amended statement of defense, the defendants pleaded how the claimant owed the sum of 1,470,000 to the first defendant as follows. On 30th October 2017, the first defendant paid the total sum of 594,915 naira 63 kobo into the claimant's Fidelity Bank account. 94,915.63 of the sum was meant for the claimant's October 2017 salary, while 240,000 naira of the sum was for the claimant's annual rent allowance. The remaining 260,000 was money borrowed by the claimant, which money has not been paid back by the claimant till today. On 21st November 2018, the first defendant paid the sum of 500,000 into the claimant's Fidelity Bank account upon request by the claimant for his annual rent allowance and loan. 240,000 was for the claimant's annual rent allowance, while the remaining 260,000 was money borrowed by the claimant from the first defendant. The loan has not been paid back by the claimant till today. On 4th March 2019, the first defendant paid the sum of 1,020,000 naira into the claimant's Fidelity Bank account as loan requested by the claimant and the claimant's allowances. 120,000 naira was for the claimant's production allowance, while the remaining 900,000 was a loan to the claimant. The loan has not been paid back by the claimant till date. In paragraph 43 and 52 of the amended statement of defense, the defendants explained how the claimant came to owe the sum of 882,792 naira to the second defendant. It was averred that the sum represents outstanding loan or money borrowed by the claimant from the second defendant, which he failed to pay, and the manner the claimant borrowed the money is contained in the second defendant's Zenith Bank account statement, and the sequence are as follows. 80,000 naira on 21/1/2018, 170,000 naira on 23/1/2018, 50,000 naira on 5/5/2018, 50,000 naira on 14/5/2018, 13,000 naira on 5/7/2018, 40,000 naira on 25/7/2018, 40,000 naira on 6/11/2018, 30,000 naira on 9/12/2018, 319,792 naira on 29/12/2018, 20,000 naira on 23/2/2019, and 20,000 naira on 13/3/2019. Let me observe that there's an inconsistency between the amount pleaded by the defendant as owed by the first defendant by the claimant and the amount claimed by them in paragraph 3 of the counterclaim. While the defendants pleaded in paragraph 39, relief 3, sorry. While the defendants pleaded in paragraph 39 and 53 of the amended statement of defense and counterclaim that the amount the claimant owed to the first defendant is the sum of 1,470,000. The amount they claimed in relief 3 of the counterclaim is the sum of 1,540,000 naira. It is also necessary to observe that there's a discrepancy in the amount mentioned by the defendants as owed to the second defendant. In paragraph 43 of the amended statement of defense, the defendants pleaded the sum of 882,792 naira as the total indebtedness to the second defendant, while in paragraph 52, they pleaded the sum of 882,892 naira. But the amount claimed in relief 3 of the counterclaim as the amount the claimant owes to the second defendant is the sum of 882,792 naira. In paragraphs 25, 27, 28, 29, and 30 of the claimant's reply to statement of defense, and in paragraph 36 of his defense to counterclaim, the claimant denied being indebted to the defendants to the amount claimed against him by the respective defendants or any amount at all, and pleaded that the sum of 260,000 naira alleged to be a loan was not a loan, but it was an end allowance or commission for ACE Project 2018. The sum of 1,020,000 naira paid into his account on 4th March 2018 was not a loan, but his outstanding allowance for producing the ACE project in 2018. The lump sum of 1,115,000 naira, which the second defendant paid into his Fidelity Bank account on 26 October 2017, was for an errand in Lagos to purchase some equipment. The sum of 882,892 naira was not a loan, but travel and upkeep allowances paid to the claimant and other staff for outstation work outside FCT. The claimant did not dispute the fact that he received 260,000 naira and 1,020,000 naira from the first defendant. His contention is that the money was not a loan from the first defendant. He did not also deny receiving the total sum of 882,892 from the second defendant, but claims that the money was allowances and not loan. The claimant even denied being indebted to the defendants to any sum of money. The question to consider, therefore, is whether the defendants proved that the monies were given to the claimant as loan, as to entitle them to recover the monies from the claimant. These onus on the defendants became more pronounced in view of relief 2, where they sought the court to declare that they are entitled to recover their outstanding loans from the claimant. Being a declaratory claim, the defendants are required to prove with cogent, credible, and satisfactory evidence that the sums were given to the claimant as loan. See Zakala versus Edosa 2018. The defendants relied on bank statements to prove that the said monies given to the claimant were loans. Exhibit D12 is the first defendant statement of account with Zenith Bank. The statement is from the period 27/10/2017 to 30/5/2019. I have seen the transaction entries in the statement. and I see some transaction in the name of the claimant being payments made to him, but the entries did not disclose the purpose of the payments or what the payments were meant for. Exhibit D12 did not show that the monies paid to the claimant in the statement of account were loans. Exhibit D11 is the statement of account of the second defendant with Zenith Bank. The statement is from the period 10/1/2018 to 16/3/2019. I have similarly seen the transaction entries in the statement, and I see some transaction in the name of the claimant being payments made to him, but the entries did not disclose the purpose of the payments or what the payments were meant for. Exhibit D11 too did not show that the monies paid to the claimant in the statement of account were loans. Other than Exhibits D11 and D12, the defendants did not produce any other documentary or cogent evidence to substantiate their allegation that the monies they called loans were indeed loans or money borrowed to the claimant. In the absence of any such concrete evidence, the result is that the defendants failed to prove the declaration they sought in Relief 2 of the counterclaim, and accordingly failed to establish their entitlement to the sums claimed in Relief 3 of the counterclaim. The defendants also sought the sum of 20 million naira as general and exemplary damages, post-judgment interest at the rate of 10% per annum, and the sum of 1,500,000 consider the counterclaim of the defendant. I find that the counterclaim lacks merit. It is accordingly dismissed. Parties shall bear their respective costs. Judgment is entered accordingly.
That's complete.
We're most grateful for the well-considered judgment, my lord.
Thank you.
Thank you, sir.
So hopefully you should get your copies, the copies of your judgment later today.
Okay, my lord. We're most grateful.
Thank you.
Yes, my lord.
So I believe we are done for the day. Did I get any appearance from Isaac Odebumi?
No, I don't know what is
Mohammed?
happening to him. I don't know what is happening to him, my lord, but I saw him online.
Well, I will record him as no appearance.
Okay, my lord.
I did that before, but I thought he would pop up while I was reading the judgment.
Okay, my lord.
All right. Thank you very much, Learned Counsel.
My Lord, I'm sorry. I'm sorry to interject. My Lord, I wanted to say that the claimants eventually showed up when your Lordship was reading the judgment, so that it can be reflected that he was there. I'm sorry. The claimants in our
in the other matter.
Yes, my Lord. Yeah, Jim or Chegede versus Transcorp.
We are done, Mr.
Edward. Okay.
Mr. Edward.
Yes,
and I cannot go back there. It doesn't matter, does it?
Okay, it doesn't matter. As you complete this.
Yes, you are here. So that's what matters.
Okay, my Lord.
Thank you so much.
Thank you, my Lord. Thank you.
Enjoy the rest of the day.
And you too, my Lord. God bless you, God.
Thank you. So I'll exit the meeting room now.
As you
I'm most grateful.
Thank you.
Yes, ma'am. You, bye-bye. Bye-bye.
Thank you.
Bye-bye.